The defense thinks that your medical malpractice case is totally defensible, and they don't want to offer a single dime. You and your attorney, on the other hand, believe that your case is worth $10 million. What do you do when the defense comes back and says, hey, listen, we recognize there are risks on both sides. Would you be interested in a high-low agreement? What do? You want to know what this is all about? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you sued your doctor claiming that he caused you significant harm and injury. And you and your attorney firmly believe that your injuries are significant, they are permanent, they are disabling, they are life-altering. And now, you and your attorney have a belief that your case is worth $10 million. The defense, on the other hand, believes that your case is worth zero. Why? Because they don't believe that their doctors did anything wrong. And if in fact that's true, and now you go to trial and a jury determines that the doctors were not liable, they were not negligent, they did not depart from the standard of care, guess what? You know how much the jury will give you? Zero. So they are willing to take the risk, at least initially telling you this, they are willing to take the risk of going to trial. They strongly believe that a jury listening to all the evidence and all the testimony is going to reach the conclusion that these doctors did absolutely nothing wrong. And in that instance, they believe that your case is worth absolutely zero. However, there is a risk. And you should know that anytime you go to trial, there is a risk. There's a risk for you as the injured patient going to trial. There's a risk to the defense going ahead with a trial. Now you might be saying, I don't understand. What's the risk of going to trial? Your attorney has taken on all the burden of all the expenses necessary to prosecute the case. You're just basically going along for the ride, right? You haven't laid out any money out of your own pocket. And by the way, if you are successful, only then will your attorney be able to recoup all of the money and expenses he paid out to prosecute your case. And then he will receive a fee, a percentage of whatever he recovers if you are successful. So where's the risk to you, the injured patient, by going ahead and going to trial? Now, I'll answer that in a second, but on the other side, on the flip side, what is the risk to the defense of going to trial? The risk to both sides is that neither side knows what the outcome is going to be. Neither side knows or can predict with any degree of accuracy what a jury, 6 members of the community, is going to do after listening to all the proof, the testimony, the evidence, the experts. There is no possible way that anyone can predict with any degree of certainty what the outcome is going to be. It's like going to Las Vegas and putting everything you have on one hand of blackjack. You don't know what that outcome is going to be. You don't know what the next card the dealer is going to pull. You don't know on the roulette wheel whether it's going to show up red or black. The reality is you don't know. So now when the defense comes back and says, listen, we'd like to consider, or we'd like you to consider, a high-low arrangement. What does that mean? It means that if the jury comes back with a verdict against the defense, and now they find the doctors are liable, they are responsible for your injuries, and now the jury gives you a substantial amount of money, millions and millions of dollars, now they will have to appeal, and now when they go on an appeal, there's still an unknown risk about what the appellate court is going to do. They could increase the award. They could go ahead and decrease it. They could go ahead and send you back for a new trial. There are many options that the appellate court has, and this is all an unknown. Now the defense says, let's do a high-low settlement agreement. We agree that if the jury comes back and says the doctors are not liable, you still get something. Let's put that number at $500,000 as an example. And now, if on the other hand, the jury comes back with $20 or $30 million verdict, you agree that we don't have to pay that full amount. We're only going to pay a fraction of that. Let's say $5 million. Okay, so now it's a wide range between $500,000 and, let's say, $5 million. Many times, the range is not that large. They might turn around and say, okay, we'll agree to a high-low arrangement of, let's say, $500,000 and $1 million. Or something else that's negotiated that's reasonable for both sides. If the jury comes back and now they give you $1 million, what happens then if it's somewhere between what you have agreed to in that high-low arrangement? What that means is now you will go ahead and keep that $1 million. That is the amount that you will keep. Why? Because that's the agreement. That anything that comes in between the low amount of 500 and the high amount that you agreed to of 5 million, that's the number. And nobody's going to appeal from that. Great. What happens if now the jury comes back and gives you $25 million? Sorry to say, but you have already agreed that you will accept the maximum of $5 million. What if the jury comes back and gives you $10,000? What happens then? Based upon your prior agreement with defense counsel, you will automatically receive the minimum amount of $500,000. Is this a smart thing to do? The answer is you have to have a very, very detailed conversation with your attorney to make an educated decision about whether or not this is appropriate for you. The reality is that now you are running the risk and hedging your bet that if a jury comes back and gives you nothing or less than what the minimum amount you agreed to is, you will now walk away with a guaranteed amount of money. If the jury comes back with something in between, great, you keep that amount. If, however, the jury comes back with a significantly higher amount, unfortunately for you, you now have to accept that lower amount. Why? Because that was one of the risks that you agreed to prior to going ahead to trial and taking a verdict. So why do I share this great information with you? I share it with you just to help you understand what happens in these medical malpractice cases, especially during settlement discussions. Now each side is trying to hedge their bet. Each side is trying to reduce the risk associated with going to trial. And I have to go back for a second. What is the risk to an injured patient going to trial? There is risk that you will go to trial, put on all of your proof, put on all your testimony, put on all of your experts, and although you believe you have a great case, and although your attorney believes you have a great case, a jury may not believe that. So you run the risk that a jury is going to throw you out of court without you getting a single dime. No matter how much you say it's impossible and that would never happen, the reality is, yes, it does happen and it is possible. And you can't just turn a blind eye and say, hey, it could never happen to me because I have a fantastic case. So keep that in mind as you are deciding whether or not to go forward with a possible case. And I understand that the reason you're watching this video is to learn more about how these cases work in the state of New York. You know, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.